Securing financing is often one of the initial steps to successfully owning and running a business. However, even astute borrowers can be caught in a terrible loan situation. A couple of precautions can help lessen common oversights. Get everything in writing. Every one of the terms and points of interest of the loan should be specified in writing. A lender may make oral guarantees and agreement. However, borrowers should depend only upon written documentation. A legitimate doctrine called parole evidence rule denies any confirmation of oral statements in court if they conflict with the written loan documents. So be careful what you offer as security. Although there are couples of specific decide that can be connected all around the real terms of a loan, one general guideline is never offer something as security that you cannot live without. Mindful loan lenders may ask for more security than required, and all assets voted as security or at risk of loss should the loan default. But oftentimes, loan lenders ask for security from the borrower, as well as an insurance from a corporate officer of the business, perhaps a deed of trust on their property. In such a case, if the loan should default, both the borrower and the guarantor are at risk of losing their collateral because the terms of the loan legitimately permit foreclose. So understand the loan agreement before signing. So lawful doctrines intended to avert deceitful lending can sometimes inhibit the borrower's lawful remedies should sometimes turn out badly. Therefore, it is imperative to completely understand the assertion before signing it. And legal counselors are among the few people besides investors who can promptly deal with and understand the points of interest of a loan. If you have questions about the loan or your rights, find legal guidance. But lawyers can be costly, but you are hiring an expert who will secure your best interests. The downside of hiring an advocate is should there be litigation, and the bank may state that because a lawyer examined the report, they could not have exploited you. Abstain from signing releases, jury trial waivers, or arbitration clauses. Loan understandings often contain a jury trial waiver or an arbitration condition, at the point where, when concurring to such terms, know that you are giving up conceivable significant lawful resources. So also, if a moneylender is stressed over a conceivable claim, they may ask the borrower to sign an obligation release. And by signing such a release, the borrower forfeits rights to a claim. So it is vital that if there is doubt of wrong movement, consult a lawyer about the matter before signing a release. Make a move if something doesn't seem right. Under a lawful doctrine called waiver of fraud, if a borrower associates a moneylender with wrongdoing but continues to get substantial benefits from a similar lender, for example funding from loans, the borrower may lose the capacity to later seek after a fraud claim. This doctrine puts the borrower in an uncomfortable situation. If you complain to a moneylender about a dubious practice, you may lose your funding, but to not do as such may bring about you losing your claim. In addition, the statutes of limitations set deadlines for filing claim. If a claim is not documented within the proper amount of time, it will be rejected. Know your rights. Basic legitimate information on borrowers' rights can be found in libraries and online ad websites, for example findlaw.com, which can also help locate a lawyer in your general vicinity with expertise in banking and finance law. But a few business loan is filled with problems because they are not all cakewalks either. So securing a loan that satisfies your business financial prerequisites while returning your rights can be complicated. Exercising a component of caution and foresight can save a headache later on. If you have taken a business loan or plan to, at that point, read on. These guidelines will enable you to deal with your loans effectively too, so keep the lender in the circle. Remember to inform your lender about all the real happenings in your business. Whether you influence a certain profit or keep running into a loss, let know your lender regarding it. Communication sets up a feeling of confidence in the moneylender and enhance a relationship. it is vital to have good relationship with the lender at all circumstances. But try not to miss installments. This may sound self-evident, but it is a vital point if you have an open business loan. You must be disciplined about repaying your loan. Try not to miss even a single installment. Suppose you cannot pay the whole sum in a specific month, talk your bank and fix a minimum adjust that you can pay. This is important to maintain your credit history of loan repayment and your connection with the money lender. Pay additional when you can. If you have a sudden windfall in your business, throw in additional money into your loan account. It is a great decision to pay off as much as you can and reduce your debt. That said, always analyze the interest rate of the loan with the conceivable saving rates. If you can procure more by investing the money, at that point do that. But put the money in a reserve and use this store to pay the EMIs at a later month when your finances are tight. And take after the guidelines that I just mentioned to deal with your business loan well. All you require is a little discipline. If that is set up, your loan management attitudes will automatically come through. Let's get into the next lesson right away.